versus LaDonna Renee Lewis. And you are here with your attorney, Mr. Nayland, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
All right. This is the arraignment, the point where the judge formally presents the charges. Look at how composed the defendant appears. That calmness likely comes from not yet grasping the seriousness of the situation. These are felony charges, not minor infractions. The real weight of what's ahead
to be determined by the court on or about November 8th, 2020. Restitution will be paid in the amount of $8,966.09. 2023 in Jefferson County, Texas, you committed the third-degree felony of misapplication of fiduciary and then or financial property of an amount more than $30,000 but less than $150,000.
Misapplication of fiduciary or financial property. In plain terms, she's accused of mishandling money she was trusted to manage. The alleged amount? Somewhere between $30,000 and $150,000. That's no small error. It's the kind of figure that makes prosecutors lean in.
Convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine is up to the judge to decide how many years. Is that what I'm going to do?
Whether or not it's deferred or straight probation and the terms judge.
Okay. So what I think I'm going to do, there's really ways we're getting all this recommendation being made. Touch their pad with your hand. This is all marks.
Right. It's just, this is just.
Okay. So I'm going to take bindings. They didn't used to do this, and now they're acting. I'll check out community. An agreement's been reached. Did y'all agree on a term of years on probation, or is that
you're just going? That's your call. There's restitution, and then we're going to ask you to decide whether it's straight or deferred in the terms.
Okay. The agreement is she would be placed on probation.
Yes, sir. Yes, sir. There's just no blank check that says just probation.
Okay, is that your understanding of the plan? Because the way this reads, there's no agreement of probation, deferred consideration, regular probation to make a contract here. It just says restitution, and this can be up to 10 years in length. It's the court's call, but whatever term of probation the court assesses, it can be shortened to 1/3 if you do well. And
one says deferred, and one says after conviction placed on probation. There's no one that says court to determine type and length.
The options on the table are straight probation or deferred probation. Straight probation means she's convicted. It stays on her record. Deferred probation, on the other hand, gives her a chance to avoid a conviction altogether if she plays by the rules. For future job applications, that's a game changer. here. 10 years of probation could be reduced to just over 3 with good behavior. It's the legal version of do your homework, get extra recess. But don't get too comfortable. Probation isn't easy. One misstep, and that shortened timeline could jump back to the full 10.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. So you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily noted. You know what you've been charged with? The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. I think we need a pre-sentence report. So everybody can then sound in, and because deferred, regular probation, one's got a conviction, one's not, and it depends on factors and circumstances that I don't know about. Okay, what we'll do is we're going to order a pre-sentence report. You will touch base with the probation officer here in a minute, and you will come, they will interview you, and they will make a report. We will return back on.
We're going to tentatively set for September the 26th, Judge.
September 26th.
Everything.
Commissioner Bone? Yeah. All right, don't drop on over.
Maybe that chair lift.
That's good.
I called China while you were with.
Correct.
You said September 26th?
Another Friday.
Yeah, I get up. I'm not sure I gotta be in Tampa on this that case that week, but it's the beginning of the week.
So that's good?
Yeah, that's good.
Okay.
All right, we will return. Then you will get a copy here, and then all parties can add any additional information you want me to consider, and the court will be fair.
Yes, sir.
And this is all fixable. And look, I'll tell when it comes to restitution,
the judge makes it clear.
You pay the restitution.
We pay the
back,
nearly
you're gonna get
$9,000,
Judge, out of what
and
she
things
takes,
will
you
go
already
more
paid back over
smoothly.
20.
She's already paid $25,000, which definitely works in her favor. In fraud-style cases, restitution is everything. It's less about punishment, more about repairing the financial damage.
The people aren't getting interest on it. They're not getting interest, which isn't, I think that's unfair, actually. But the quicker you get them paid back, the quicker they can use the money that was lost. And that, you get rewarded for that, okay? Just a little word to the wise, but restitution is a key part of this case. Okay, awesome.
Thank you.
Thank you.